all want to make money by doing something we love. If you could turn your hobby into your job, you'd never work a day in your life, right? Welcome to Hobby Hustle, the ultimate podcast where collecting passion and business collide. Now, here's your host, Zach Nigett.
Welcome to episode 20 of Hobby Hustle. What is going on, everybody? I'm so glad to be here with you. I'm your host, Zach Nigett, and thank you for taking time to spend with us. If this is your first time tuning in, welcome. No matter if you're a new listener or you've been listening for a bit, please be sure to like, subscribe, rate us, and of course, share with your friends. Also, if you're watching on YouTube, please be sure to leave a comment with any thoughts or suggestions that you have. I greatly appreciate your support, and I hope you enjoy today's show. Today's guest is a lifelong collector who is also passionate about practicing law. He became an attorney in 1999 after graduating from Tulane University. He now works as a plaintiffs and intellectual property litigation lawyer. Over the years, he has combined his passion and skills as a lawyer with his collecting interests and enjoys following and writing about legal issues in the sports memorabilia and trading card industries. You can find him on IG at Paul Lesko or on X at Paul_Lesko. I'm honored to welcome a fellow collector, litigator, and the unofficial hobby lawyer, Paul Lesko, to the show. Paul, welcome, my friend. How are you?
Good. Thanks for having me on, Zach.
Thank you so much for being here, man. So, I mean, you're obviously a lawyer. You're into the hobby and collecting. So is there currently any sort of interesting legal case that's going on that you're following?
You know, it's really funny because I started collecting way long time ago, but I started following lawsuits in the hobby in about 2010. And that's because there was a lot of intellectual property issues that are there, but there was also lots of filings. So then that has only increased. So every morning what I do is I wake up, and before I start working, I have a number of databases that I look at to see what's out there. And I am currently monitoring over 50 lawsuits in the hobby right now.
Crazy.
So there's always something going on. But my favorite one right now, and it's funny because, you know, there's some really big lawsuits that are out there. I'm sure we'll talk about the Panini and Fanatics antitrust lawsuit. You know, it's one of the biggest ones. That's probably the biggest one that's out there. Yeah. But, you know, sometimes it's the small ones that I find the most interesting. That there's a trademark infringement lawsuit between Ultra Pro and BCW, where Ultra Pro alleges that it owns the words, basically the trademark, the words for penny sleeves and top loaders. And that nobody else in the hobby can use those. Okay. So Ultra Pro sued BCW saying, hey, you infringe our trademarks. You're using these phrases. They're ours. We have trademark registrations for it. And BCW says, this is ridiculous. These phrases everybody uses. They're generic. No one company should own them. So what's funny in that lawsuit is Ultra Pro ultimately dropped the lawsuit inexplicably, just dropped it out of nowhere. But BCW said, no, and they sued Ultra Pro on their own to try and kill these trademarks. So that's kind of that fun one that I always like. It's kind of like the Grandpa Simpson meme where he walks in and then turns around and walks out. Well, you know, they just grabbed him and pulled him back in and said, no, we're not done with you here.
Interesting. Yeah, you know, I mean, we'll get into it maybe a little bit later on in the conversation, but, you know, just generically speaking, right? Like those general terms like top loader, penny sleeve, from your perspective, obviously, I'm sure you haven't dug into every single little detail, but like, I would think to your point, like that's a generic term, sort of like a term of trade, if you will, like that shouldn't be able to be protected. What's sort of your quick take on that?
Well, you're exactly correct. It's I've been using the term, and you know, I'll base it off of my experience in the hobby. I've used the term top loader and penny sleeves interchangeable with any company I've ever had for years. Yeah. You know, whatever I get in the mail, you know, any card I get from eBay, it's in most times it's in a penny sleeve and in a top loader. And I've never once associated that with Ultra Pro. Correct. And you know, that's what you need to win a trademark infringement case, is that here's this phrase, I hear this phrase, and I think Ultra Pro. Yep. But when I think top loader, when I think penny sleeve, I just think protecting my cards.
Yeah, pieces of plastic.
Exactly. Yeah, and so that just goes to show it's a generic term. Everybody uses it. It's not like kaboom or something. You know, when you think of, you know, when you hear the word kaboom, your first thought is it's a Panini product. Yeah. Prism, that's a Panini product. Yeah. Penny sleeves, well, that's a neat thing to protect my cards with.
Totally. Well, that's good. That's an interesting frame to have, like I said, as we get into this later bit. So, you know, with all my guests, I like to go back to the start. And for you, I'm curious if you could tell us a little bit about how you sort of got into collecting and some of those early memories.
Sure. I started collecting about 1986.
Okay.
I was living in the suburbs of Chicago, 12 years old.
Me too, man.
Were you really?
Yeah,
Nice.
yeah.
Being 12 years old and in the suburbs of Chicago, I obviously collected Mets. Dwight Gooden.
Totally. That's a logical fit.
Yeah, to the exclusion. I did not collect Michael Jordan, so that was a real big mistake on my part. But that's what got me in. Love baseball. I love the Cubs. I love the Cardinals. I love the Central, and I love the Mets. And I love Dwight Gooden, the way he pitched. He was electric. He was amazing to watch. So that's what pulled me in and initially got me collecting. So,
that's awesome. You love the Cubs and you love the Cardinals, Paul. I don't think you can say that together, man. Like that's sacrilegious.
I'm a uniter of peoples. So I living in the suburbs of Chicago, you become a Cubs fan, and then most of my mom's side of my family and some of my dad's are all from the St. Louis area.
Got it.
So I grew up with both of them, and I think those are fan bases. They are, it's not like the Yankees and the Mets. It's not like the Yankees and the Red Sox. There's bad blood there. Sure, there might be some bad blood between the Cardinals and the Cubs, but it's. I was at a game this year and I was sitting next to a bunch of Cubs fans and we just had a blast. I mean, it was a really good time. There's no threat of violence when you're at those games.
No, totally. Well, I mean, the Cubs for the longest were the lovable losers. And, we got our World Series, which was pretty cool. But I think that also probably plays into part of it, right?
Right.
That's awesome. Well, I know that sort of over time, your PC is very unique and that's evolved. Can you talk to us a little bit about what you sort of collect now?
Sure. So I probably did what most collectors do. There should be like an evolution of how people collect.
Totally.
Because when you first get into the hobby, you're looking for those, I'm going to make it rich. I'm going to find a prospect that nobody's thinking of. I'm going to buy all their cards and they're going to take off and it's going to be the next, MJ 86 Fleer and I'm going to be rich. So I have a healthy collection of cards and autographed rookie cards that aren't even worth a quarter right now. I mean, I got like crates of them. At that point, then I decided, you know what? Collect what you like. And I really, enjoy covering the lawsuits that are in the hobby and cards with legal issues. So I said, you know what, that's really what I should collect. Any card that's involved in a lawsuit, any card that has legal issues, collect those. And then I can display those in my office at work. And it's, twofold there. It shows, my love for not only trading cards, but I can actually teach people about certain issues. Like, with the whole penny sleeve and top loader thing, it's just, if you have them in your office and you're explaining what they are, it's much easier to get the issues too.
Totally.
And it gives you, when you see baseball cards, this card's great. It's his rookie card. It's a Topps. His player is awesome. But hey, did you know there was this controversy about how it was made, or this person copied, or this should not have been on the card? I think it just adds another layer of like the behind the scenes business that, because courts are public, everybody gets to see. So that's really what my collection is. So cards involved in lawsuits, cards with legal issues, and I also like collecting what I call my fair use cards, which are really like art cards that are probably pushing the limit and probably are infringing, but they're hoping to hang their hat on fair use to say that they're not infringing.
Well, I love that you collect those, and I definitely want to get into that a little bit later on. I myself have started producing some of these original art cards, and so that's, I think, a hot topic. So we'll definitely get some insight there. But that's a fascinating way to go about collecting, and I think it's cool because, part of collecting is the story behind all these items, right? Like, otherwise it's just a piece of cardboard, or it's just a shoebox, or it's just a magazine, or whatever it might be. So I think that's really awesome that not only can you display it, but you have these really cool stories to be able to associate with it. Speaking of that, obviously we all are chasing something. Is there like a grail piece that you can't obtain or that's really hard to find that you're looking for?
So there is a John Henry 2011 Topps Triple Threads card. It's out of 5.
Okay.
And the reason I'm looking for that card, I mean, it's a bizarre insert of a fictional character, but there was a lawsuit about it where Topps took a picture, utilized a picture of a former employee whom they fired on this card, and he alleged they did not have the rights to use his image. So there was a lawsuit about it. And 2010, 2011 is when the lawsuit was filed. And one of those cards popped up on eBay and it was going for $200. And I've got a math background. I've got a science background. I've taken a graduate level statistics classes. I knew, there's 5 of these cards. There's one of them on eBay. This is probably the only one that's there. Yeah. But in my head, I'm like, well, there are 4 others. And, it's $200 right now because it's a brand new card. I had not spent $200 on a card
Sure.
at that point. So I let it go. And I set up my alert on eBay, and it's one that goes right to my phone if it ever pops up. And here we are 13 years later, and I have not seen another one of those cards pop up.
Oh, man.
So,
all right. Well, we'll be on the lookout for the John Henry card, but I know that feeling, man. You know, when it tugs at the heartstrings when we're looking for those random PC pieces and there's a price and it's like in your head, where does that price fall? But you know, some of those ones, like you said, lesson learned for sure. You know, the out of fives, even some of the out of 10 stuff, like that's tough, you know, like you might get one shot, but hopefully we'll track it down for you one of these days soon, Paul.
Yeah. No, and it's always embarrassing when I go to card shows because, you know, everyone's got their, you know, their best, most modern cards that are up there. And I'm like, do you have a 2011 Topps triple threads insert that nobody cares about? I mean, the look I get from dealers is just like, seriously, dude, come on. You think I'm carrying a card like that to a show? Give me a break.
They're like, dig through my dollar boxes. You might find it in there.
Yeah.
That's awesome. Well, hey, let's shift gears a little bit because I want to get more onto the business side of things. So, you know, obviously you have a passion for sports and collecting, but I'm curious how your love of law sort of came to be. Can you tell us a little bit about what made you decide to get into law?
Sure. It's kind of funny, actually. So I have a background in the biological sciences, and my goal was to do something with that. But there was it was either late high school or early college, I read a book called Primal Fear, which they eventually, you know, made a movie from with Ed Norton playing, you know, one of the characters in there. And there was just a line, you know, or a little section of that book where it talked about the main litigator in here had, you know, torn the other guy apart so badly in court that he went to the bathroom and threw up. And that just for some reason just got a hold of me. It's the fact that it's verbal warfare. It's a verbal warfare game that you could actually get into with practicing law. And that's something about that just sunk into me. So even though I had a scientific background at that point, I really wanted to head towards law school. And, you know, it worked out well for me because at the time I came out of law school in '99, there was a big push for attorneys with scientific backgrounds because patents were becoming big dollar ticket items. There was a lot of big litigation that was out there. So it worked out well. But then I quickly, you know, I still do litigation involving science whenever I can because most lawyers don't like science. They don't like math. So if they have one, it's easy to get cases that way. But I quickly went from trying to draft patent applications, which I thought was the most boring thing ever, got into the courtroom, was able to litigate my own cases, take depositions, have trials. And it was definitely the right choice because I've never made anybody throw up before. I've made people break out in hives during depositions. So I think that's close enough. But yeah, no, it's a fun business.
So, you know, you should be shaking in your boots a little bit when you see Paul across the courtroom from you, man. I like that.
No, I'm a puppy. Everyone knows I'm very friendly in all my depositions, but if you're lying to me, and I know you're lying to me, it's not going to go well for you.
There you go. I like that. That's awesome. That's interesting. So, like, have you actually I know that you have this passion about the collecting side and sort of combining this. Can you talk about how you sort of figured out putting together collecting and law? Like, how did that all come about?
Yeah. I mean, just luck. I mean, it really did because, you know, there was one day, and it was right before I started writing about the industry. I noticed that I just looked at a baseball card and I saw it had a copyright notice. It had a trademark notice, rights of publicity. I mean, every time you look at a card, there is so much law surrounding a card. And back in 2010, there was a lawsuit where Topps sued Upper Deck because Upper Deck came up with some insert cards that looks a lot like 1975 Topps baseball. It very much looked like the same type of cards. And there was a lawsuit over that. And when you're in the legal business, the law firms always want you to get into some type of client development, writing articles, you know, making appearances, doing things like that. So I'm like, hey, I can write an article about this lawsuit. You know, you guys interested in that? And they're like, yeah, we'll find you a publication for it. And, you know, so I wrote an article, found a publication, they published it. I thought it was a pretty interesting lawsuit. It was an interesting piece. And as soon as that was out there, I was starting to get contacts from social media, from collectors and from websites that were in the hobby saying, hey, would you want to write for us? Would you want to do anything with us? And I thought, for sure, because you're supposed to do an amount of client development. I am directly talking to future clients, and it's something that I like, and it's my collection. It just worked out really well.
That's awesome. That's really cool. Yeah, I mean, I can only imagine some of the stuff that you've seen, because I do know that you wrote for Cardboard Connection and you've done a lot of other things in your career. I need to go dig through the archives to try to find some of that, but that's really cool. And I know that you're active on Twitter, X, or whatever it's called, right? Again, at Paul_Lesko. You have a lot of commentary there. And I did, share your IG. I know you're not as active about that, but it's very cool, man. And I think it's really interesting that you've taken this. So I know that you've written about this and you talk about it. Have you actually had an opportunity to be a part of one of these cases?
So I do have clients and have had clients that are in the industry. And while I'm a litigator, I often encourage early settlement or settlement before even filing a lawsuit, because lawsuits they're difficult. They really are. I mean, you're going to have to produce like every document you've ever had. You're going to have to sit for a deposition, and it's a roller coaster, because any decision that's made, while you think you have the strongest case in the world, it's still a person on the other side. And I've won some cases I should have lost, and I've lost some cases I should have won. Once you add that variability, you just don't know what's going to happen. So I've done lots of work with in the hobby, but probably the biggest thing I ever did was I, as a plaintiff, sued Topps at one time. It was when Topps Now had just come out. There was a Josh Harrison card that was produced, but the image that they showed was a typo. It said John Harrison instead of Josh Harrison. And so I was kind of excited, because I'm like, hey, this is the first error card for Topps Now, I believe. It'd be a fun one. So, I bought the card and I tweeted, hey, look, there's this John Harrison card. I'm pretty excited to get an error card. And then Topps changed the art and said they're not going to issue a John Harrison card. It's going to be Josh Harrison. So I made it clear. I'm like, hey, you made an offer. I accepted the offer. You need to comply. And so, tried to work it out outside of court. Didn't work. So eventually filed a lawsuit over that. And, the lawsuit settled to the mutual satisfaction of everybody. And now it's one of my favorite cards.
It's part of the PC, man.
So you can see the Josh Harrison and the John Harrison.
That's awesome.
Side by side.
Did they have to print one for you?
Well, let's just say I have one.
Okay, perfect. I love it.
And there are multiple ones that are out there too.
Okay. That's really interesting though, specifically though, because Topps Now is specific to like, that breaking event, that milestone thing. So it's like for them to have an error on that is pretty egregious, if you ask me, because it's like, this is the only thing that you're making this for. So good on you for being able to have one of a few copies that do exist.
Yeah. And one of the jokes that's out there now is if you buy on Topps Now, you can see that there's a disclaimer saying that, Topps reserves the right to change the art, fix any corrections that are out there, or fix any typos or other things that are out there. And that's been known among the community as the Paul Lesko warning.
I love it. There you go. Now everybody knows where that came from, man. That's awesome. So let's get into some of the legal stuff within the hobby specifically. So right now, one of sort of the hottest forms of card sales and where some of these companies are really pushing is breaking, right? Yeah. I'm curious from your thoughts from a legal perspective on, are there major legal concerns, or this is just sort of gambling and it is what it is? Like, I would love to hear your take.
So I think breaking can be done correctly.
Okay.
But if it's not done correctly, you can get into a lot of trouble because it's an unlawful contest or a sweepstakes. To be an unlawful contest or a sweepstakes, what you need to have is you have to pay some money for a chance to win a prize.
Okay.
Not everybody's going to win. Somebody's going to get stuck holding the bag, and somebody's going to get something actually really good. That
Sounds is like breaking.
yeah. No, that's and it's an unlawful contest there. So the way that I think you can structure a proper break is by what a lot of people are doing now is by, whenever you buy a card product from Topps or Panini or anybody, there is always a no purchase necessary option where you can submit a card or, submit a postcard, send it to them, and they will allegedly do the same odds that anybody else has that you could potentially win the prize or a prize. Mm-hmm. And that's, how the manufacturers have done that forever. So the manufacturers do that to get around the whole contest sweepstakes issues with their products. So some breakers have brought that over into their products by saying, hey, if you send us an NPN option, or you want the NPN option, we will submit the NPN option to the company for you. So I think that gets around, is one of the ways that gets you around the whole potential illegality of brakes. But yes, there are a lot of ways that brakes can fall apart, like RASs. I think RASs are illegal. I don't think there's any way to fix a RAS. A RAS is where a bunch of people enter and only one person wins.
Yeah.
It's
a lottery, right? Like,
9 out of 10 people are going to leave with nothing. One person leaves with everything. I don't think there's a way you can fix that. And I think, some brakes, depending on how they do it, could be problematic also. And I think, you're seeing that with sometimes where you'll see people pull cards and then shut down the brake or refund everybody's money.
Yeah.
I think there's some potential bad actors out there, which shows why, you should have brakes monitored, or, they should be better regulated than they are.
Yeah, no, 100%. So I'm curious, like when you're talking about the no purchase necessary stuff, like that would be specific to, you said a company, right? Like I send in my postcard to Paul Lesko Brakes, right? And then you, in theory, are sending that along to whoever it is that I'm maybe trying to win this, specific card from or whatever. But as a breaker, if I'm doing like a team break or, whatever it might be, a player break, and again, this is all hypothetical, but is if you as the breaker offered me, say, hey, send it in and I'll give you a chance, or I'll send you a card, does that sort of get around from a legalese standpoint, like that no purchase necessary, or is there another level to it that I'm not understanding?
So the no purchase necessary, what that gets around to is the prize. When I look at breaks, I differentiate it between two types of cards: the commons and the prize.
Okay.
And, there's some people who don't even want the commons. They tell the breakers to keep the commons.
Yeah.
So I think, when you have team breaks, everybody's assuming they're going to get some commons. So the NPN option, I think that is more so for the prizes.
Okay.
And I think, the manufacturers are specific to product. So if you submit to a NPN for a 2024 Prism football, then you're going to potentially have a chance of winning a prize from that. So I think if it's run that way, I think that gets you around it. Now, I'm not, big disclaimer, I'm not a contest sweepstakes attorney. Specialize in that.
Yeah.
I'm the person you call afterwards after your contest sweepstakes has fallen apart, or if you've been ripped off by a contest or sweepstakes. That's when you talk to me.
Yeah, no, totally. And that is a good disclaimer, but I'm just curious, right? Like I love being able to pick your brain about these types of things because this is a big deal. The other thing too is obviously the whatnots, the fanatics, live, all these, like these are all people that have, to your point, sort of unregistered, unlicensed. They're trying, I think, as best they can to regulate this stuff. But, how does that sort of fall into, as far as responsibility from a legal standpoint? Is that on the breaker? Is that on the platform? Like what's your sort of take on those things?
Yeah, that'll really turn on the terms of service.
Okay.
What nobody ever reads.
Yeah.
Terms of services will probably go into really big detail about what everybody covers and what they don't. But from the litigator in me, if I see a whatnot break or another break that's gone bad somehow because the breaker shuts down or tries to refund money or palms a card and inserts another card there, at a minimum, there should be a lawsuit against those individuals. If the platform, depending on what the terms of service says, maybe there's a lawsuit against the platform itself or an arbitration for it. But, sometimes they're not necessarily the bad actors. It's the bad actors that you want to get in the lawsuits.
Sure.
themselves.
Yeah, totally. No, that makes sense. And again, another major disclaimer. There are a lot of good actors, right? And there's a lot of people out there with good intentions. There's a lot of really amazing people who are breaking, companies, individuals, and it has become a major business for these people to support themselves. So I am by no way meaning, and I don't think you are either, Paul, putting a major poo-poo on breaking. It's just something that's very interesting from a legal perspective, and that's why I wanted to make sure to bring it up with you. So.
Yeah, no, I agree. I think probably 99% of breakers are honest. You don't really, I've never been involved in a break that had any issues. I don't know.
Me neither. Yeah.
So I think most, it's always the exception to the rules that are out there. there. And it's one of the people, if you have a very good business, if you've been around for a while, you're not going to risk it over one card. You're not going to refund one break to, jeopardize your entire business.
Yeah.
So it's not, so I don't think it's the big guys that are out there committing issues. I don't, I don't know if you want to talk about it. I don't believe in loaded boxes being sent to breakers either. I think, when you're some of these big breakers and you're buying 40%, 50% of a product.
Yeah.
You're gonna statistically
odds are, yeah.
Yeah.
No, totally. And that's a whole nother interesting topic for another show with the loaded boxes and stuff. But I'm with you. I don't think that the casual hobbyist understands that some of these breakers do pull in 20, 30, 40, 50% allocation on a product. And so when they're getting a lot of the hits, it's because they've bought a lot of the product. And sure, I'm sure the optics, like anything with luck, can be really bad where, a big name hits a big card and then, automatically it's thought foul play. But who knows, man? You and I aren't behind the scenes that much, but I'm with you that there's other things at play there. So speaking of legal issues and big players, I know that one of the biggest cases that's been ongoing for a while in the hobby is this Panini versus Fanatics case. Are there any sort of interesting updates or new information that's come out recently? Because I know it's sort of been on the back burner for quite some time.
Yeah, the biggest update about the Panini versus Fanatics case is that antitrust cases take a long time to do anything. So it's just they're so interesting cases because it's not really should be viewed as one case, but it's kind of a spider web of cases that's out there because originally Panini sued Fanatics because Panini alleged Fanatics raided, I think it was like 35 of their employees out of their Texas headquarters and that they weren't supposed to do that. And then there was another lawsuit filed by Panini alleging antitrust issues. And then Fanatics filed a lawsuit saying there's unfair competition issues. You sat down to negotiate a deal with us over passing over the NBA and NFL licenses, and you didn't do that in good faith. So you have these like direct lawsuits against each other. But then you have these peripheral lawsuits that have branched out also, where you had Panini and WWE were suing each other because WWE tried to end their license, their exclusive license early to go to Fanatics. And then you also had Panini and the NFLPA were involved in an arbitration because the NFLPA tried to end their license early to go over to Fanatics. So you can kind of view it as this whole spider web of issues that all really has to do with the same thing, the exclusive licenses in the hobby, who's going to control them in the near future. So where we are currently right now is both sides have basically filed briefs saying that the other side's case is completely worthless, you're completely wrong. They're in front of a judge now in what's called a motion to dismiss, and the judge will eventually decide whether these cases will go forward. The former employee case, that case, early on, Fanatics lost its motion to dismiss, just meaning that the case will continue. That's up on appeal. So really all those cases are at what I would call the motion to dismiss phase. The judge needs to say, hey, there's a real case here or there isn't, and then we'll know from there. Okay. But antitrust cases are notoriously complex. They're long cases. Whenever I see an antitrust case against a large company, it's easy to say that it's a 3-year case. And that's just at the district court level before you start going the appellate route.
Wow. Okay. So this can play out for some time. I guess as a amateur law knowledge person, what is there like a deadline that these judges, like you said, that it's, up for review by the judge? Like, is there a deadline that they have to make a decision or refile, motions or papers? I apologize. I'm ignorant to all.
No. It's there is a, federal judges where typically antitrust cases will end up are appointed for life.
Okay.
But there is a kind of a 6-month deadline where if there's any pending motions, if there's anything, you have to act within 6 months.
Okay.
Now there's ways to get extensions here, and that 6 months, the way that 6 months is calculated, I think it's closer to 9 months. It's very weird how it works. But any stage in the process, there should be some action should happen about every 6 months.
Okay.
And I think we're past that.
We're going to the 9.
Yeah, but when it comes to an antitrust case, it's very difficult to hit every single issue. It's not like they moved to dismiss and said, hey, here's the one unique issue. There's basically, hey, here's the 17 ways this claim should be dismissed and the 13 ways it should be dismissed. So it just takes a long time for a judge to go through each one. And, judges are fairly knowledgeable about the law, but they don't know every in and out. So
Sure.
they have to assure themselves, look at both sides, look at their cases, do their own independent search for cases. And because it's lasted so long, maybe some new cases are popping up. So it's a difficult job. And sometimes I don't think it moves quick enough for me being a lawyer, but you can see how it could take a long time.
Yeah, totally. Well, that's interesting. Well, we'll see how that shakes out at some point in 25, or at least we'll get some sort of notice as to what's moving forward or not. So the traditional license card world sort of keeps plugging along. But what I'm really interested in talking to you about is there's been a major rise in what you alluded to earlier, sort of the non-licensed custom card art space. I'm curious, just at a general level, what's your take on this stuff?
I do a lot of speaking also, and I've spoken with musicians, artists, writers. And whenever I have a workshop discussing about legal issues, it always happens at some point, it breaks down to how much of somebody else's work can I steal legally?
Yeah.
And that's really where you're looking at for some of these art cards. There are so many issues that are there. You have trademark issues, copyright issues, right of publicity issues, that it's difficult to say carte blanche across everything, whether there's issues or not, because there are ways to do things correctly. There are ways to have a better fair use defense than others. There's some good things that are in the public domain too. But the way that I always look at it is, if you as an artist are looking at somebody else's intellectual property, and that's the major basis of what you're doing, and you're making not just one work of art, not like a unique piece, but you're making a product that you are selling multiple copies of, do your due diligence, because if you're borrowing somebody else's IP, you're making a lot of something to make money off of, you very well might be infringing some type of intellectual property right.
Okay. Interesting. So, there's a lot of questions that I have to go with this, but let's start here. So, as far as artistic license, it's a little bit of a gray area from like a legal perspective. Obviously, a portrait of an athlete, a portrait of a character, these types of things. Like like I said, from a legal perspective, where do you think that line sits as far as, I create an image, that I've hand drawn, or, however I manipulate this image to come up with it, not a photograph, right? Because a photograph I think is different, but what's your sort of take?
It's going to be, the favorite line for lawyers that frustrates most people is, it depends.
Okay.
because when it comes to an original work of art, the first issues that you're looking for is copyright infringement. And a complete defense to copyright infringement is if you have a truly original work of art. In other words, if somebody, without ever seeing the Mona Lisa, drew the Mona Lisa,
sure,
it's unlikely. But and again, Mona Lisa is not subject to copyrights too.
Yeah.
But if somebody would actually just not having ever seen the Mona Lisa, drew the Mona Lisa, that is actually a defense, because in order to infringe a copyright, you have to have access to the copyrighted work and basically access and copying. That's what you're looking for. So if you've never had access to a alleged infringing work, then you're probably okay for copyright. But then you get into other issues, trademarks. You get into issues with right of publicity, and it's always thorny there. It depends on what you're doing. There's a couple cases that are out there. There's a Tiger Woods case. There's a University of Alabama case that are out there where the artists made limited numbers of like famous moments during, famous Alabama moment, famous touchdown that occurred in that instance, where very limited copies were made. I think it was less than 3, potentially even 1, that, it was allowed to make a painting of a famous moment or a painting of Tiger Woods at a famous moment. It's always going to be an it depends issue. If there's a photograph out there and you make a painting of that photograph and there's trademarks on there, well, you've probably added the issue of, you've copied a photograph that somebody else took and worked it. So it's always it depends. It depends on how much more you're borrowing from other people. And it really depends on how many of an item you're selling.
So let's talk about that. The how many of an item you're selling. Like, is there a definitive line in the law that states If you exceed X, you are violating. What, from your perspective, is that?
I think the only line is you're safe with one.
Okay.
After that, I mean, there are cases where there have been multiple copies, 2, 3, where that line is. Unfortunately, it's probably going to be determined by state law rather than federal law. Each state or each circuit is going to look at it differently. So we really don't have a fine line that's out there. And sometimes, depending on how much you rip off, I mean, if you have a painting where you paint, let's do the Mona Lisa again. Let's say you look at the Mona Lisa and you paint the Mona Lisa, you're not going to be able to have a fair use defense for that because you've just literally copied the other side.
Yeah.
If you've added something to it, transformed it somehow, made it your own, then you have a better chance. And that's what, gives rise to the fair use defense.
Sure.
And that is the most difficult defense to predict because every judge has their own views on it. What's fair use for one judge is not fair use for another. There's the famous case that's out there is the recent Warhol case. And I can't remember. Oh gosh, I'm flaking on the subject matter, but it went to the Supreme Court and it was Warhol. It was Prince. Warhol painted a group of his, his different color pictures,
pop art, picture, colorful,
of Prince, and the photographer sued, saying, he didn't have a license to do that. Well, the district court and the Court of Appeals were completely on the opposite side of each other. One said it was completely infringement, no doubt about it. The other side said it was completely fair use, no doubt about it. And then the Supreme Court came in and, muddied it up a little bit, but basically said, if you are creating a product or copying an image and you're in the exact same field, like if you're copying a trading card and you're making your own trading card from it, your chances for claiming fair use are diminished.
Okay.
So that's, it's not a fine line.
Yeah.
But it goes to show you if you're a card artist and you're copying another card that's out there, your fair use defense is probably a little bit weaker than you think it should be.
Okay. That's actually really interesting. And that's a really good tip. So good to know. I guess from again, I just want to pick your brain because I have so many questions, Paul. But when we're talking about, you've referenced the Mona Lisa, or you just referenced a specific card. If, you're recreating that image on a card, I get that. Right. But what about things like sports athletes or TCG characters or even like popular culture icons? Are there any differences when artists are using these subjects?
Yeah, there are, because then you're getting into trademarks and right of publicity. And while ultimately fair use is grounded in the First Amendment, and the First Amendment applies to everything, the more other rights that you're infringing, the more permissions you probably need from everybody else. So when you're creating especially TCG characters, that's going to be, really troubling if you're going to make multiple cards or multiple images that are out there, because those characters are protected by trademark, by copyright, and the companies, like Pokemon, Nintendo and Pokemon, are fairly aggressive in enforcing their rights. And there's also regardless of if you're legally correct, if you face a lawsuit by a multi-billion-dollar company, who's going to win? So
most people will probably get squashed. Yes.
Yeah. And sometimes that's what companies bake on. If there's a close issue or an issue that maybe isn't close, but they know they can get away with it, they'll bring those because, legally, here's what they protect. But if they can convince people that they actually own this, then, it's all the better for them. It's like the most frustrating thing I ever hear, watching the World Series yesterday, and the announcer comes on and says, images and descriptions and, of this is, subject to copyright and we own it. I'm like, descriptions? Really? I don't know, what you're saying for that. So, but, if companies can convince you that they own more rights than they do and they stop other people from infringing, then that's, good for them.
So that makes me think about like these cons and stuff, right? Like a Comic-Con or a Star Wars Fest or whatever it might, Pokemon, right? Whatever it is. So many of these vendors, sure, they're selling licensed stuff, but there's a ton of fan art, right? Vendors that are set up with fan art, and they're selling likenesses of all these characters, and they're selling multiple copies. So like, how does that play out? Or is it just that, these big companies just don't care at that point because it's so little? Like, talk to me a little bit about how that works from a legal perspective.
Yeah, I think some of it might be that when you're talking about a convention and they have, somebody, if they're selling a one-of-one fan art, I don't think they care too much about that.
Yeah.
5 copies, 10 copies, how are they going to enforce that? I think part of it is, these companies do police their works.
Sure.
And the easiest way to police the works is obviously on the internet. Just, go to Etsy,
Yeah.
go anywhere else and look for the things there.
Yeah.
It's hard to have feet on the floor of every convention to go to every single booth and say, is this licensed and this is not? So it's a numbers game, really, more than anything else. I can assure you some of the companies that are fairly aggressive will, if they're there and they see it in the booth, will say, you can't sell this. It happened to me once when I was a kid at the first Lollapalooza. We went and on the way in, somebody was selling shirts. I bought a shirt on the way in because I didn't want to spend $40 inside. It was a $15 shirt outside. I was wearing it. I walked through and I started walking around, and one of the vendors started screaming at me. He's like, "That's infringing stuff. Somebody get that." So that was my introduction to it. It really depends on how are the vendors, can the vendors see it, and how aggressive do they want to be?
Yeah. Interesting. Okay. Because that was like one of my biggest things. So you also mentioned Etsy, right? There's obviously other platforms, eBay, other places where, these artists are selling stuff versus maybe a private website, right? Like a specific direct to consumer website. Are there any protections or any differences between there, or online sales is online sales, period?
Online sales is online sales. There's probably some protections for Etsy and for eBay if they don't know about it, they're not required to police it.
Sure.
That's why you probably heard of DMCA takedown notices, where what that is it provides a safe harbor for eBay or Etsy or other online sources where if you have to notify them first and say, hey, there's an infringing item on your website. If eBay or Etsy complies and takes it down rather quickly, then you can't sue them, and you can only go after the original seller for those. So that's what that is. They're not doing it out of the kindness of their heart. They're doing it to ensure that they can't be sued over this.
Sure. Yeah. Okay. Well, no, and I do know that, like, I've seen vendors removed completely for copyright infringement, things like that. I just didn't know. Okay. That's interesting.
It's a numbers game. It really is, because, and then sometimes licenses are complex. You don't know who all has licenses. I mean, it's easy in the world of exclusives, but when it comes to companies that have, 10, 15, 20 different licensees, you don't want to make them mad. So you have to do a little bit of due diligence, and sometimes a day or 2 days isn't sufficient.
Yeah. Interesting. Okay. Very cool. So I know you'd mentioned like ripping off a card design is probably not a great idea, like a specific design. And I actually had listened to a different interview that you had done about the Bang Bro cards, and that was a big deal with Prism because it was a direct just rip off of the design. But that's for another conversation. But I'm curious about, like, you mentioned also earlier, kabooms. So what about like parallels, variation names? Like I believe that like the term superfractor is trademarked. So should artists avoid using those? What sort of the legal, ramifications of some of those types of things?
Yeah. So it's funny that you say this. There's a little bit of a lot to cover here.
Okay.
So, and I'll start with the superfractor because amusingly yesterday, so every Tuesday, the trademark office publishes trademarks that have already passed review for opposition, which means, hey, everybody in the world, unless somebody has a problem with this, a legitimate problem with this, we're going to give this company a trademark registration. So yesterday, Topps Superfractor trademark application was actually published for opposition. So if nobody opposes that in 30 days, Topps will own a registered trademark for Superfractor.
Interesting. Okay.
Which means, when it comes to litigating over infringement, I mean, they really get the benefit of the doubt as to having a legitimate trademark on the phrase superfractor on trading cards.
Yep.
So, So, you have, and that's not the only superfractor, they have superfractor, they have taco fractor is pending still. Frozen fractor is pending.
I think they can keep those.
Yeah. But then you also have, but you also have trademarks on, products, Prism, Chrome. Those are trademark registrations that the companies have. Now, when I said kaboom, I probably made a mistake there, because Kaboom, Panini did try to get a trademark registration for Kaboom. The
Okay.
trademark office said no. They rejected it because they said that there were like other trademarks out there for Kaboom and comic books and Kaboom for stores. And so a Kaboom on a trading card isn't sufficient to be registered. Now, that doesn't mean you're free to copy it, because you could still claim state trademark rights, or 43A of the Lanham Act claim. It's just a weaker claim. And that's something that came actually to light in the Bangros case, where that was, there was infringement of a number of Panini's trademarks. And the judge noted, okay, every single one of these trademark registrations you've mentioned, I'm going to give you full dollars, Panini. But I noticed that Kaboom, you don't have a trademark registration for that, so I'm giving you $0 on Kaboom. I don't think that was the correct way for the judge to do that, but Panini was getting its money, and it's not like they're going to get $600,000 out of an individual that was infringing.
Yeah.
But yeah, so you have to be careful when it comes to card design, when it comes to trademarks. The manufacturers, they are getting some pretty good controls over that. Now, I've tried to encourage, many times, the manufacturers to actually take out copyrights or trademarks on the actual card designs themselves, like 1975 Topps. Why not file a trademark on the frames, or file for copyright registered frames themselves? Arguably they have trademark rights in those, because when you see, 86 Fleer, you think, Fleer, you think Upper Deck. When you see 75 Topps design, you think Topps. 86 Topps design, you think Topps. So they do have some type of trademark rights there. They just don't have that registration in hand, which I think, as you can see from the Bangros case, judges actually put a lot of credence into whether you put that R with a circle with your trademark there.
Interesting. All right. Well, this is all really, really good stuff, Paul. I appreciate all this insight. So, as far as the art card space, there's obviously not only a ton of artists producing it, but there's become this whole secondary market, right? That some of them are being sold on eBay, some of them are transacting privately and on other sites and stuff like that. Is there any sort of concern there that some of that will get shut down for like not being able to sell a specific artist or anything along those lines?
I think it hasn't really been tested too much. I think a lot of the bigger card artists, like Piggy Banks,
Totally.
I think he produces, under 10 copies of everything. And I think even when he produces under 10 copies, each one copy is different than the others. Is that legal? Well, I think it's close. It's something that's real close to it. I mean, he's really trying, and that's, why, when it comes to the Piggy Banks works of art, don't call them cards. They're works of art. I mean, there's really a push on their point to try and do it that way. But if there are cards, I mean, we don't know. Has he ever received a cease and desist letter? Maybe.
Not to my knowledge. I have had the opportunity to speak with him, and he's a very stand-up guy, and he has some really unique takes on that, and I think he's very prepared to get one of those letters, and how he's going to go about handling it in a professional manner. But to date, I don't know that he has received one.
Yeah. And, and if he has, I mean, it's not like he's received too many of them. And if you do receive a cease and desist, it might be a one-off from, some athlete, or, because you just never really know what's out there. And, just in case, along the lines of collecting cards that are involved with potential legal issues, I do have, I had 4, I now have 3 Piggy Bankses, because I figure at some point we might see him on the docket, whether rightfully so, or, or a poor lawsuit against him. It's something that I think there's a chance for it in the future.
Yeah. Well, I'm with you. I've followed him from the start pretty much. I had an opportunity to meet him back in 2022, and fell in love with his artwork, and the stuff that his studio and himself are putting out is amazing. And then there's a ton of these other artists that are coming to the market. I would like myself to be included in that conversation, that are producing really cool, unique pieces. And I think a lot of the drive behind it is just the creativity factor, right? Where a lot of these major card companies have sort of gone stale on design. You and I, being 90s guys, grew up, I think, in the pinnacle of creativity and design, and a lot of that's gone away. Not to say that there aren't cool things that are iconic with the color blasts and the kabooms and, the downtowns and things like that. But I just think that collectors want new, they want fresh, they want unique. So I think that's where a lot of this rise is coming from. But, it's interesting to your point, because technically a variation of the same image, but on a different background, could be considered a one of one, but, it's still the same image. So I guess, to your point, this is all really just a gray area, and it's going to take one person coming down on an artist or a group of individuals to figure out where this sits, right?
Yeah, and it's funny because I always try to preemptively sometimes buy cards that I think will have legal issues. So, so I mean, I love art cards. I collect quite a few of them. I got, I thought Project 2020 was amazing. I
Super
thought what
cool.
it did, it introduced us to so many different artists that are out there, and and I think because of it, like Naturel and Ermsey have done a really good job of continuing to create, their own little art cards. And the Naturel ones, I always thought those were closer to infringing than others. And so I tried to collect all of his art cards. And there was one where he had a Sabrina Williams that he made look like Storm from Marvel. And that one disappeared rather quickly from his webpage. And there aren't very many of those out there. Luckily, I got one. And I don't know for a fact. But I suspect maybe there was a cease and desist that was involved there, because some artists, that's how they make some money. Is you'll have a product where you're pushing the envelope, and that's why I love artists. I love artists.
That's part of art, right? Is pushing the envelope.
Yeah, and so what you do, you push the envelope. You try and get as many sales as possible. If you get a cease and desist letter, okay, bad, I'm done. Sorry. And you just assure the other side, I will never do it again, and hope they don't sue you anymore. And most times they're too busy. They just want you to stop. And you got your quick sales and you get your reputation out there. So I like that. That's the type of artist that I like. I like people that are pushing the boundaries and potentially could end up getting sued over it.
Yeah, sure. Well, so I guess not to beat a dead horse, but just sort of to put a bow on this custom art card space. Like I said, there's tons of artists flooding the market, as we all know. Cream will rise to the top. A lot are just doing it for a money grab. There's also a significant amount that are here to stay because they're passionate about the work that they're putting out. But sort of where do you see the future of this custom art card playing out in the next year, especially with the rise of, like you mentioned, piggy banks, who is starting to have like big dollar sales on the secondary market that is sure to draw attention of some of these larger companies?
I think that's going to be drawing the attention of companies. I think they'll be monitoring a little bit more closely. I think right now when you're, only making 10 cards, there's no line in the sand saying 10 is appropriate, but it's one of those things where a manufacturer might be more, we'll let it go, especially when you're pushing each piece is unique. And, he's not just flagrantly ripping off other things that are out there.
Sure.
But you're right. With more dollars going into this, you're going to have more artists that are going to pop up. Some of those artists are going to push, the limit a little bit more, and some of them are just going to flat out copy, and get caught. So I think as this continues to grow, I think there will be. I'm looking for the first lawsuits, and I think the Bang Bros lawsuits might be the first lawsuits that were out there, where the manufacturer, where that person that made those cards took Panini prisms, took other distinctive kabooms, distinctive trademarks from Panini, and then put porn actresses on there. Well, that was too much. They got sued and they got hit hard for that $600,000 default judgment against them. So I think where is the line? It's somewhere between Bang Bros and maybe piggy banks is somewhere where you're looking to ultimately be.
Yeah, well, it sounds like we might need to have a revisited conversation here in 6 months or a year, and sort of see where everything's at and what lawsuits have popped up. Well, Paul, this has been super amazing. I want to respect your time. I cannot thank you enough for taking the time to talk to us. But before I let you go, I sort of like to ask each guest to leave our audience with sort of a valuable tip. So if you had one piece of advice, I guess in this case, maybe from a legal perspective, what would you sort of that be for artists and entrepreneurs getting into maybe this custom card art space?
Yeah, I would think, and it's it's kind of how I leave every one of those photographer, musician, author, little talks that I give, is that if you are creating a work of art, and if that work of art heavily relies on someone else's intellectual property to the point that if somebody looks at it and doesn't initially think, hey, that's a you, that's a Topps, that's a Panini, you really, be careful because, right now, there's a lot of artists that are closer to right-click copy than actually than actually creating their own initial works of art. So don't rely on the fair use unless you talk to a lawyer about it. But the more original you are, the more transformative you are, the better it is for you and for your product.
I love it. I love it. That's awesome. So before I let you go, obviously throughout this interview, I've been popping up, where people can find you. Again, on X, Paul_Lesko, or IG, Paul Lesko, one word. But are there any sort of interesting events in, seminars, speeches, anything that you have coming up that you want to share with the audience?
Right now, every day is a seminar, because what I do, every morning I wake up, like I said, before I get to work, I look at all the dockets, I look to see what's out there, and then I tweet about them.
Yeah.
So if you roll into the office and you don't exactly want to start right away at 9 o'clock in the morning, come look at me on Twitter. I try to find the latest filings. I try to make them interesting, and I try to make them humorous, amusing, because, face it, when it comes to legal actions, those aren't very fun or very interesting. So I try to make it amusing. I try to make it very explanatory, so that people can understand what's going on. So just, check me out on Twitter. I'm there every morning.
Perfect. Well, and I will give you a huge credit for, really trying to simplify it, like you said, and taking complex situations and breaking them down. So people like me, who are legal idiots for the most part, can sort of understand what's at stake. So, Paul, this has just been an awesome conversation. As a card artist myself, this has been eye-opening, and it's going to leave me with some things to think about. But, hopefully there's also a ton of listeners out here that find this, super enlightening. So it's just been an honor to have you on the podcast. I wish you the best of luck, and I greatly appreciate you coming on the pod. So thank you so much.
No, thanks for having me on. This was real fun.
Awesome, Paul. Have a great one, man. We'll talk soon. Everyone out there watching, thank you for your time. I hope that you learned something new or found some inspiration. If you enjoyed the show, please be sure to like, follow, subscribe, and of course, please share with your friends. And remember, keep collecting, keep hustling, and we'll see you next week on Hobby Hustle, where collecting passion and business collide. Thanks so much.
Hobby Hustle is brought to you by Collector Creative. If you're a collectible brand or company looking for help with marketing, branding, design, or development, head over to collectorcreative.com and drop Zach a line. We'll be back next week. In the meantime, connect with us on Instagram, TikTok, and YouTube at collector_creative. And be sure to like and subscribe so you never miss an episode. We'll see you next time on Hobby Hustle, where collecting passion and business collide.